will always love you. I will always love you. And I wish for you joy and happiness, but above all this, I wish you love.
Yes, welcome to the La Grande finale of Legal Briefs. It is with great sadness that I announce this will be the last Legal Briefs video, but it's going to be the best. Kind of like Jay-Z's Black Album. And it's the last video because the parties have filed their last substantive briefs in the Ripple versus SEC case, so there's not going to be much more to talk about, just a waiting game from this point. So yes, this is goodbye, but not before we go out with a bang, because I'm going to be doing something today that I have never done before, and that is give you my predictions for what the outcome of the case is going to be. And remember, I am never wrong. And the reason I'm never wrong is that I always hedge my bets, and therefore my predictions will be based on the likelihood of outcomes, because there are a couple of possible outcomes here, and I will lay it all out for you in the next 10 to 15 minutes. Now, last week, the parties filed their replies to the replies of the motions for summary judgment, and that means the case is now officially in front of Judge Torres. She could render an opinion tomorrow if she wanted. She won't, but she could in theory. More on timelines later. First, let's take a quick look at the SEC's final brief. At this point, there's nothing really new that's being brought up. We are now arguing over fine points of fact or law, so I won't go into too much detail about either brief. This video is going to be about outcomes. Now, let me say this first off about the SEC brief. It's much better than the first two. The first two were not impressive, but this work was much better, and I thought it did a good job of at least giving the judge a coherent framework for its position that XRP was sold as a security. And here it is in the SEC's brief, a nice summary paragraph of the SEC's position. Quote, here the court should analyze all of the undisputed facts and circumstances. This includes defendants' statements and actions, the economic reality of XRP and Ripple's financial motivations, and contractual terms for XRP sales, if any, such as pricing, discounts, indicating an investment intent. These undisputed facts show that investors paid money for XRP, and Ripple stated it would use those funds to promote and try to find use and value for XRP. Ripple also told investors that if it was successful, demand for XRP would increase, permitting Ripple and investors to profit. XRP investors, including institutional ones, paid over $2 billion for XRP because they reasonably expected Ripple and its principal decision makers, who had a giant pile of XRP, who were very long XRP, to honor the promises they had made and to do what they were financially compelled to do. Use XRP sales proceeds to fund extensive efforts to increase XRP's value, close quote. That's a good summary paragraph. I don't like the syntax, but I also thought the SEC made some good use of the cases that it had prosecuted successfully previously by using the Telegram and library cases, and of course the Kik Interactive case, as persuasive authority. The Kik case being most problematic for Ripple, since it was decided in the very same court as Judge Torres is in, which is the Southern District of New York. Remember, the SEC for the last 4 to 5 years has been using a common long-term litigation approach, as we discussed a year and a half ago, and I used my lion analogy. So think of the SEC in 2017-19 like a young lion. Does he attack the largest bull? No. He goes for the young and weak at first. And then when he gets bigger and stronger and more confident, he goes for the bigger bulls. That is exactly what the SEC was doing. It was preying on the weak. And now that it's been eating for 3 years, it was ready for the bull. My God, I was so young when this started, and calm. So yes, the young SEC lion went on the attack, but I'm happy to report it did not find an easy meal because Ripple put up a fight like I've never seen before. I was impressed, and I'm not easily impressed. Which brings us to Ripple's final brief, and it really doesn't let its foot off the gas on any single legal issue here. First, that the SEC hasn't proven that all alleged sales of XRP involved money. Second, that XRP was not sold as an investment contract. Third, that there was no common enterprise. And fourth, that XRP purchasers did not rely on Ripple to increase XRP's price. And those are just the main issues it addresses. It's really a big brief. And Ripple also has a nice summary paragraph, and here it is in its brief on the bottom of page 4. Quote, in short, the SEC is asking the court to rewrite the statutes that define its authority. For the SEC to prevail in its opposition, the court would have to endorse the SEC's theory that there can be an investment contract without any contract, without any investor rights, and without any issuer obligations. It would have to endorse the SEC's theory that there can be a, quote, common enterprise, even if the SEC cannot say what the enterprise is or prove any of the elements that define such enterprises. And it would have to endorse the SEC's theory that purchasers could reasonably have expected profits from Ripple's efforts, even though Ripple never promised to make any efforts, even though it expressly disavowed any obligation to do so, and even though profits were overwhelmingly due not to Ripple's efforts, but to market forces. The court would also have to conclude that all the amici that have expressly said they did not join a common enterprise or expect profits from Ripple's efforts are wrong about their own beliefs and actions, close quote. And that is a very nice summary of Ripple's position. And now that it is all on the table, and I've spent a lot of time thinking about the arguments and the cases, I am now proud to present the legal briefs, Ripple versus SEC case predictions. Now, I've read every pleading in this case. I've listened to every single hearing. I've researched every issue. I've read other opinions from Judge Torres just to see how she approaches making a decision. I've even conferred with retired federal judges about it. Boy, they hated me. And here is what I think. Here we go. I believe there are 4 possible outcomes to the Ripple litigation, and because I know you like preciseness, I have given each possibility an exact percentage chance of happening, and I will start with what I think is the most likely outcome, with exactly a 50.1% chance of occurring, and that outcome is, drumroll please, I think there is precisely a 49.56% chance that Ripple wins at summary judgment. A win for Ripple at summary judgment because XRP was not sold as a security. Complete Ripple victory, and I think there are 2 bases for this and possibly a 3rd basis as well. The first basis for why I think Ripple will win, and the most likely, is that I think Ripple will win because it had no legal obligation to purchasers of XRP after the sale occurred. No post-sale obligations. In other words, there can be no investment contract without an investment contract. Now, I want you to know that I've spoken with other lawyers who believe that Ripple may win on this issue on an appeal, but not at the trial court level because it's such a drastic ruling that it kind of smells like it's more appropriate for an appellate court to find this and not a lowly level trial judge. But like I've said, I've read other opinions from Judge Torres, and I think she is exactly the type of judge that would make a brave ruling such as this one. And I think Ripple will win on this issue because it is right. I don't think Ripple will win here because the SEC didn't respond well or did something wrong. I think Ripple wins on this because it is correct. And in the last month, Ripple has received unexpected backup on this issue from the Paradigm Operations amicus brief. Paradigm is an investment company, but in its brief, it cites to the work of one of its law firms, which actually did something quite amazing. It must have taken a year or 2 for them to do it, but they reviewed 266 legal decisions related to securities violations, and in their brief on page 2, it states, quote, a comprehensive analysis of federal and appellate law reveals that no authority exists to support the SEC's attempt to transmute the Howey analysis of an investment contract transaction into a conclusion about the underlying asset. In every application of Howey where an investment contract was found, there was some identifiable legal relationship between an ostensible issuer and the investor providing investment capital. The evidence is clear in the Ripple case that there is no ongoing legal relationship between Ripple and XRP purchasers. There's just none. And the SEC has failed to address that problem. In fact, one of the cases that the SEC relied on in its reply brief cited to a case called Davis v. Rio Rancho Estates, and in that case, the court actually held that, quote, there was no management contract between plaintiff and defendants, nor were defendants obligated by the purchase agreement to perform any such services. And in the absence of a common enterprise between the parties, the expectation of a profit on resale is insufficient to transform what is essentially a sale of real property into the sale of an investment contract, close quote. So what that tells us is if the Howie company today was to sell the exact same orange groves that it did back in the 30s without any post-sale obligations to the purchasers, Howie would have won that case. In fact, Howie probably wouldn't have even been sued in the first place. And there's no legal distinction between that situation and the situation between Ripple and the people who bought XRP on Coinbase, for example. There's just no difference. It's basic statutory construction. The law requires an investment contract, not a sales contract. And that's exactly what we have here. We have Ripple selling XRP, not making any legal promises to do anything further. Just here, I'm selling it to you, I'm taking your money, and that's that. That is the sale of an asset and not a security. And so, my best guess is that Ripple wins on that issue because I truly believe that to be the correct outcome. But let me move on because I'm too passionate about this and I've probably bored you by now. Now, as I told you before, most attorneys who think Ripple will win at the trial level think it's because the SEC will have a difficulty with the common enterprise, which is the second prong of the Howie test. And some of these people are much smarter than me, so we do well to talk about that. Now, the law requires a common enterprise between the seller and the buyer of an asset. And in the state of New York, where our case is, the Revit case is binding authority, and it defines a common enterprise as one in which all of the investors' assets are pooled together and the investors all share the risk of profits and losses from the scheme. And the SEC struggles in its latest brief, and it really struggles with explaining what exactly the common enterprise is or was. This is perhaps the major issue in the case, and the SEC spends only about 6 out of 55 pages talking about it. And here is the SEC with its best effort to date on that issue, which is on page 7 of its final brief. Quote, investors reaped their profits in the form of the increased value of the token that all investors held, and Ripple established a common enterprise by pooling the funds and using them for its operations, including the construction of the digital ecosystem it promoted. This ecosystem was crucial, close quote. Okay, so that's the best it can explain what the common enterprise is. Fair enough. Now, that being the case, the SEC has two big problems with that. First, the XRP ledger had been in existence long before the sales were made, so none of the sales money was actually used to build the ledger. And that is a problem with the common enterprise theory. But putting that aside, and second, if you are going to hang your whole case on the appreciation or depreciation in the token value, which is kind of required by the Revit case and those lines of cases, you better be able to prove that the token value is tied to Ripple's efforts. Otherwise, you have no common enterprise. And you also don't have another prong of the test, a reasonable expectation of profits. Now, actually, at this point, the SEC has to not only prove it was a reasonable expectation, but you actually have to prove it happened, because otherwise there'd be no actual common enterprise. Now, that's one of the problems with waiting 8 years to sue someone in this type of case. But the SEC has 4 major problems in this arena with the common enterprise argument. First, how can any purchaser have reasonably relied on Ripple to increase XRP's price when Ripple had no post-sale obligations to them? It's like buying a Tesla and then suing Elon Musk when it fails to increase in value.
What is that actually? Yeah.
The second problem the SEC has is that Ripple, through attorney John Deaton, have actually submitted hundreds of affidavits from actual XRP holders, many of which had never even heard of Ripple when they bought XRP. And third, while the SEC has apparently abandoned its expert witness on the issue as to whether Ripple's efforts had any effect on the price of XRP, Ripple's expert witness analysis is that, for the most part, and especially since 2018, and as you probably know, the price of XRP moves based on the crypto market in sync, and it doesn't really move with any business moves that Ripple makes. Now, in response to those problems, here's an example of the evidence that the SEC has to show that XRP purchasers reasonably relied on Ripple for price increases.
So again, all we're concerned about is trust, utility, and liquidity. Grow the network. That actually will be the best thing for the value of XRP and the best thing for the entire protocol.
That is Mr. Chris Larsen from 2014, and those are definitely the types of statements that hurt Ripple, but this is a court case and that is evidence. So the question is, has the SEC met its burden to prove that anyone reasonably relied on that one interview on YouTube and saw that and said, you know what, I'm gonna go buy that XRP because that Chris Larsen guy looks like a nice guy and he says they are working on increasing XRP's price. I mean, the SEC has to kind of tie those loose ends together with proof, with evidence. And I just don't see the evidence that it has. I don't even think there's any evidence that any XRP purchaser even watched that video. So, as you can see, in my opinion, and at least three other lawyers' opinions, the SEC has a big problem on the common enterprise prong. And also attached to that, I think, a problem with the expectations of profits prong. And those smart attorneys think that that will carry the day for Ripple with a complete victory. Now, put down the champagne, my friends, and put on your big boy pants. It's time to have the difficult conversation because the legal brief's prediction of the second most likely outcome from the Ripple versus SEC lawsuit is my second prediction, with a startling 29.99% chance of occurring, is that Ripple loses. Yes, that is a distinct possibility, and I am not going to lie to you. Do not listen to anyone who ever tells you that a court case is a slam dunk or can't lose. Now, I've lost cases I should have won. I've won cases I should have lost. As summary judgment, we are relying on one person, one judge, to decipher a lot of complicated new information and make very difficult decisions. This is not a simple case. And how could Ripple lose, you might ask? Well, it's actually much simpler than the Ripple wins analysis. I think step number one in that process would be that Judge Torres decides that the fundamental statutory analysis of whether investment contracts require post-sale obligations is too novel an issue for her to decide that the issue should be decided by an appellate court. And I've seen judges make that kind of determination before. And it's also true that for Judge Torres to make a big decision like this, and it would be a big decision, it would require a lot of bravery on her part. And sometimes it's easier for a judge to rule against you, knowing that you will then appeal, and then let the appellate court tackle the issue, and then the judge at the trial level doesn't have to deal with it. Now, next in that process of Ripple losing, I think Judge Torres would evaluate the 4 prongs of the Howey test and agree with the SEC that there existed a common enterprise because Ripple simply used the money from the sales of XRP to fund its business. And especially from 2013 to 2018, there really wasn't much consumptive use for XRP that we have evidence of, and it must have been bought, therefore, for speculative use. And what about the reasonable expectation of profit prong? How would Ripple lose on that? Now, the one thing the SEC did a good job of in its earlier briefs is laying out all of the statements, emails, YouTube videos of various Ripple employees talking about the price of XRP. I mean, they had 8 years worth to work from. So Judge Torres would look at all those statements and agree with the SEC when it states at the bottom of page 9 of its brief, quote, "The question is whether Ripple led potential investors to reasonably expect profits from its efforts. That is an objective question answered by economic reality and Ripple's representations, not by individual motivations," close quote. But wait, before you pick up the phone for the Suicide Prevention Service, let me explain one more thing here. When I say there is a 30.1% chance of Ripple losing, that includes a loss that is not really a loss. And what do I mean by that? So, Brad Garlinghouse recently said that Ripple, I think, has $1 billion in the bank, a billion with a B, and a ton of XRP in escrow, of course. In other words, it can lose, be ordered to pay a crypto record disgorgement and fine, and it could stroke a very large check and probably continue on its business. So then the question becomes, well, exactly how much would a likely loss cost Ripple? Would it put them out of business? Well, It depends. Here's a chart from the SEC's initial complaint, which shows how much Ripple is alleged to have sold illegally. There, as you can see, from 2013 through the third quarter of 2020, the SEC alleges that Ripple sold $1,388 million worth of XRP. So those are the possible damages, plus a fine, of course. So by these numbers, what I'm suggesting is that even if Ripple were to lose 100%, it might be able to weather that storm financially and survive. And if, for example, the judge decides that only sales of XRP up through 2018, when the on-demand liquidity use case came into being, if only those were illegal sales, then the disgorgement amount becomes almost half of that, and surely Ripple could weather that loss intact. So I'm including as a loss those situations where Judge Torres splits the baby and decides that early sales of XRP were sales of securities, but at some point the sales lost that designation and became non-security sales. This is a result that I used to think would happen, and I think Attorney John Deaton was also in favor of it, but recently I've begun to see it as less likely. Why is that? Mainly because Judge Torres has to make a reasoned decision. She has to write out her opinion, and she has been handed a mess. Certain sales of Ripple were made to institutional sales, some were made in the open market, some sales were sequestered from Ripple's general funds in separate accounts, some were not. Some sales were made to US citizens, many were made to non-US citizens, and those sales don't count under US federal law. I mean, in order to split the baby, you have to come up with a logical place to cut, and no judge could figure this one out. She would have to make an initial ruling and then rely on the parties to tell her what amounts are what. It's a very difficult situation, but anyway, that's too much detail. Let's move on from talking about a Ripple loss to our third possibility for the outcome of the Ripple case. Drum roll, please. The final possible outcome, which gets exactly a 19.14159% chance of occurring, is a surprise ruling which does not provide us an immediate winner.
Say what?
Yes, Stewie, I am talking about a decision that does not end the case. As we have talked about possible outcomes of the case, has anyone here been thinking, well, what about the fair notice defense? What about the Hinman emails? Well, that's something that has been a little overlooked in these briefs. The Hinman emails make an appearance in Ripple's brief on page 23, but are only used to back up a very specific point. It's beautifully redacted. I said before that I think the emails only go to buttress Ripple's fair notice defense. I didn't really think they were going to be relevant to the Section 5 violation. So even though it's redacted and I don't know what it says, my instinct is that Ripple forced a reference to the emails here because it kind of wanted to get in the juicy bad stuff in them in front of the judge in these briefs. And since it's not arguing the fair notice defense in this brief, this was the only way. I see you, Ripple. I see you. Which leads to the big gamble that Ripple took and why the case could possibly not be decided with these motions, which is my third possibility. What Ripple has done with the fair notice defense is that it has gambled with it and argues in its initial brief that it is not proper for the judge to rule on the fair notice defense, but that a jury should decide it at trial. And then it stopped arguing about it. I don't think its last two briefs it even talked about it, which is dangerous because the SEC has continued talking about it. And then in this last brief, it argues that the judge, not a jury, should decide the fair notice issue, meaning it should be ended here. And why does the SEC think the fair notice defense shouldn't go to trial? I read the footnote at the bottom of page 31, and I was surprised how candid the SEC was. Quote, there are practical reasons why such defenses are not and should not be heard by juries. Allowing the defense would greatly lengthen government enforcement trials by permitting defendants to proffer evidence about the SEC's internal deliberations and the beliefs of countless market participants. This would require rebuttal from the SEC, further lengthening the trial, close quote. In other words, Judge, the fair notice defense shouldn't be tried to a jury because Ripple would be able to offer evidence about what we, the SEC, actually did or didn't do, and we'd have to defend ourselves. You can't let that happen. That made me both laugh and cry at the same time. But if the judge agrees with Ripple that the defense should go to a jury trial, which I think there's a strong argument for, the general judicial mindset could be, well, if we're going to have a jury trial anyways, well, we might as well have all the issues in front of them. It's economic, and also it takes away the pressure from me, the judge, from having to rule on this strange technology crypto issue, which I don't really understand and I don't really want to have to understand. So therefore, I'm going to find a factual dispute which I can use to then send the whole case to a jury and take the pressure off of me, a lowly trial judge. So this actually happened to me this year. I had an issue that obviously should have been decided by the judge, but she just wouldn't rule on it. We even tried 3 times to get it in front of her, and eventually I think she just wasn't sure what to do with the case, so she just had us try it to a jury. So that happens. And that is my third possibility, the possibility of a jury trial. And although Ripple might be chomping at the bit to try this case, you would not be happy because a trial would not happen until at the earliest the summer of 2023, and maybe even after that. But that kind of is what it is, as they say. Which brings me to my fourth and final possibility for the outcome of this case, and that is that the judge does something crazy that I haven't even thought of, like, I don't know, she grants Ripple's fair notice defense or does something sua sponte on her own accord, which no one could have thought of. Now that possibility has exactly a 5.3% chance of happening, maybe 7%. I can't discuss it because I don't know what it might be, but the fourth possibility would be something no one has really contemplated, and that does happen in litigation sometimes. So, in conclusion, the Legal Brief's official lawsuit prediction is a 50.12% chance of a Ripple win, a 29.88% chance the SEC wins with a possible Ripple loss but win in there, a 19.11% chance of a draw this round with a trial in 2023, and a 5 to 7% chance of something unexpected. In other words, there's a 110.6% chance of something happening shortly. And finally, when will we know the outcome of the case? My friend, Attorney James Filan, says it will happen on or before March 31, 2023. And if that's what he says, that is what it is. It's like a proclamation from a legal god. And that's it. Now, my friends, it's time to say goodbye. If you don't like sappy stuff, close your eyes. You know, life is kind of funny in hindsight. Little did I know reading the lawsuit back in December of 2020 that it would change my life. Through these videos, I've learned a new area of law, made new and good friends, and enjoyed myself immensely. And I want to thank all of you for watching. Really, truly, thank you very much. And more importantly for me, I want to say thank you to my kids for putting up with all this nonsense. They essentially lost their dad and mom, you know, on the weekends, Saturdays, Sunday nights, while we were doing this stupid legal brief stuff. I just want my girls to know that I felt like people were relying on their mom and dad to keep them up to date, and that we saw this through to the end, and it was the right thing to do. And finally, the biggest thank you to my wife, Tin Vu, who really does most of the hard work editing and splicing together all of my mess ups. You are amazing. Thank you very much. And with that, I wish you all the best of life. Enjoy it every day.
Thank you for watching Legal Briefs.
Mic drop.
It was so much cooler when Obama did it.
And now we go off into the sunset.
Well, it's actually sunrise, but you get the point.